Rajesh, can you hear me?
Yes, yes. In between, we lost you. Maybe connectivity problem.
Yeah, I hope that that doesn't happen again.
Hopefully, sir. Sir, we also have our Regional Services Division Director,
Yes, sir.
Dr.
Good
Yusuf.
morning, sir.
Namaste, namaste. Nice meeting you, sir. Nice meeting you. Nice meeting you, Dr. Priya. Rajesh, I am now in Mysore.
Yes, yes.
I had come for a function here,
Yes, yes.
and I'm joining in from the guest house here. So they don't have a Wi-Fi unfortunately here, so I'm using my uh,
Okay, sir.
mobile.
Okay,
So
sir.
so I hope it goes fine.
Yes, yes. I don't think it will be a problem. Normally, we get good reception, even
Okay.
on the basis of this. So, shall we start, sir?
Oh yes, oh yes.
So, uh, Pandit sir, shall we start, sir?
Yeah, definitely, please.
Good morning, everyone. It is a very important day in our calendar because we are conducting a series of programs on the occasion of Constitution Week. And this is perhaps the most important program that we are organizing on this occasion. Today, we are going to deliberate on a very important topic, the role of judiciary in maintaining the resilience and vitality of the Indian Constitution. And to speak on this very important subject, we have a luminary in the area, and it is none other than Justice Shyam Kumar, the sitting judge of the Honorable High Court of Kerala. It is our privilege and honor that Sir has extended his time to join this very important function in spite of his very busy schedule. Without much ado, let me now request our respected Regional Services Division Director, Dr. UC Pandey, sir, to welcome our chief guest. Over to you, sir.
Thank you, Dr. Rajesh. Very good morning, everybody. I welcome all of you to this webinar, which has been organized as a part of Constitution Day celebrations in IGNOU. Today's lecture has been organized on a very important topic, that is the role of judiciary in maintaining the resilience and the vitality of Indian Constitution. And our chief guest is an eminent legal expert, Honorable Justice Shyam Kumar, Judge, Honorable High Court of Kerala. First of all, let me sincerely thank our esteemed chief guest, Justice Shyam Kumar, who is an expert on maritime litigation and arbitration. We are really honored, sir, to have you with us today, and we are extremely grateful to you for agreeing to our request to address the staff of IGNOU. We have with us on this occasion regional directors of different regional centers, staff, students from different parts of the country. And they have joined us online. Some of them have joined online. Some of them have joined through social media also. So because this lecture is being broadcast simultaneously through YouTube and Facebook also. So I welcome all the colleagues, friends, and the students who have joined us online. Dear colleagues, our country has taken major strides since independence, and the credit goes to the persistent adherence to the values enshrined in our constitution. It is a document. It is a document which not only reflects our aspirations but also gives us an assurance and shows ways to achieve them in an inclusive manner. The people in constitutional positions have maintained the sanctity of this sacred text. We have an eminent expert person from the judiciary to educate us on the role of judiciary in maintaining the resilience and the vitality of Indian Constitution. I am hopeful that all of us will get benefited by the expertise of our esteemed chief guest, and we look forward to have some meaningful deliberations. Now I request my colleague, Dr. Rajesh, to initiate further proceedings.
Thank you, sir. Thank you for your kind words. In fact, before we invite the very esteemed and honorable chief guest of the day, Justice Shyam Kumar, sir, to address us with this lecture, I would like to give a brief introduction of his accomplishments in the field of law before we continue with the proceedings. Uh, Justice Shyam Kumar, sir, obtained his law degree from the Government College of Law, Ernakulam, and enrolled as an advocate in the year 1996. He joined the chambers of his a very eminent father, T. Gopakumar, who was an advocate in Thrissur and obtained LLM in maritime law from the School of Legal Studies, Cochin University of Science and Technology. Sir joined the chambers of S. Venkateswaran as a senior advocate, the High Court of Bombay. Sir has specialized in areas such as admiralty and shipping law, commercial and constitutional law, and what is more, he is also a very proficient academic. Sir was an adjunct associate professor at the National University of Advanced Legal Studies, Cochin. Sir has also taught maritime law, law of the sea, marine insurance, etc., in various institutions across the country. And further, Sir has been associated with very many vital and seminal cases in various capacities. I would like to mention two of those very, very seminal cases. One in which he acted as amicus curiae for the Honorable High Court of Kerala, that is in the Thanur boat accident tragedy case. And Sir also appeared for the defendants in the very, very important case, that is Enrica Lexi case, where he represented the slain fishermen in the honorable courts of the country. Sir has a number of distinguished achievements, which rolls into several pages, but due to paucity of time, I wouldn't be able to recount all of them. And I also take great pride in mentioning here that Sir is also my guru. I was fortunate to have been taught by him for a semester for the LLB degree, and that was a great experience because when I look back, I always find that the hallmark of a great guru is when you remember his words again and again and instances again and again. And after so many years, even today, when we relate to anything about maritime law or the law of the sea or SOLAS or even the recent Baltimore accident case, immediately the words and what all Sir taught in the class immediately comes to my mind. So I take immense pleasure and I consider it as an immense honor to welcome once again the eminent jurist, the Honorable Justice Shyam Kumar Sir, to this function and request Sir to take over and further conduct the proceedings. Over to you, Sir.
Thank you very much, Rajesh, for that very kind introduction. Esteemed dignitaries and my dear friends online. I hope that I am audible. I am loud and clear. Rajesh,
Yes,
kindly
sir.
confirm.
Yes, sir, sure, 100%.
All right, thank you. Thank you. Let me begin by expressing my sincere gratitude to IGNOU and also Mr. Rajesh, my dear student, for having invited me to address you all on this topic, which is very dear to me and which I feel is of great relevance and of contemporary significance. I congratulate the IGNOU and also for the person who had chosen this particular topic for discussion because this actually sums up what it is to be done now or how we should approach the constitution document that we have and how we should study it and also understand and take a stock of how it has been functioning and what exactly has been the role of judiciary as a limb of governance in furthering the objectives of this document. I think there are many ways in which we can go through this subject, but I think that as Socrates would say, let us define our terms before we proceed to discuss on this topic. We need to have our terms very clear and certain. And unless we know what we are defining our terms with, the discussion wouldn't take us anywhere. So we need to understand what we mean when we say a judiciary. Well, and also what is the kind of document that we are discussing about, the constitution as such, before we come to the peculiarities of the Indian constitution and the role that the Indian judiciary has played when it comes to the interpretation of the constitutional tenets that we have evolved for ourselves. So constitution in jurisprudence, we would term it as the grand norm, and the grand norm being the one from which, or somebody would some would term it as the grund norm, because that's the way it is pronounced differently. So the grand norm or the grund norm essentially means the fountainhead from which all other tenets of law would emanate. So in a republic like that of ours, we have this constitution which acts as the grund norm, and there is nothing above the constitution, and that acts as the most preeminent legal norm that is in force in the country, and everything would be done and the governance would be subject to the tenets as laid down in the constitution. If we look at the way in which constitution has been dealt with or the necessitated across the world in different countries, we find that it is not a document that is has to be there invariably for governance. There are countries which do not have a written constitution. Constitution could be written or unwritten. By constitution, what we essentially mean is the norms by which the governance of the state has to be carried out. So there are monarchies, there are single party governance systems, there are democracies as we have, and within the democracy, there are different forms of uh, governance that we have, the parliamentary and the presidential forms. So essentially, the question as to whether a constitution in the form as we know it in India is found across the globe, well, it may not be so. But generally, if we look at the democracies across the globe, it was always been found that, especially if it is a diverse democracy, then it is always better to have a written constitution. So we are very clear about what we have made for governing ourselves, what we have laid out for governing ourselves. So constitution by its very nature assumes relevance because it lets us know what are the principles that guides us in furtherance of our polity, and what would be the norms based on which the governance would be done. So it assumes importance because of the fact that that is the document, ultimate document to which we always get back to whenever we are faced with a situation where we need to decide which course to take in the life of a nation. So when we are at a juncture when we could take one or more different courses, we refer to this document again and again and try and understand what exactly is it that we have given unto ourselves for the purpose of getting an idea as to where to proceed from the situation that we are in. So, by the very nature of this document and by virtue of its importance, it has to be a comprehensive one, which ought to take in not only the kind of polity or like kind of system that we have given unto ourselves, but it should also reflect what we are. This is something that applies irrespective of the barriers of a state. See, whether it is India or any other state, any country or any society that decides to give a constitution to itself will have to necessarily ensure that the document that they have evolved should reflect the ethos, the culture, the tenets that the society or that particular grouping considers itself to be bound by or important to them. So, to sum it up, constitutions differ. There cannot be a straitjacket method for a constitutional document. It depends on what we want to give ourselves. And its importance lies in the fact that it lays down the basic principles on which we wish ourselves to be governed by. Now, after having said that, what should be the essential ethics or the principles on which such a document should be based is the next question. There are some basic principles with which the humankind has been grappling all through the civilization. We have tested out many forms of governance, and we have found that it has been very difficult to keep tyranny at bay. We found that once the powers, like creating a law, executing it, and also deciding as to whether that the law has been complied with or not, if it is rolled into one single person or entity, there is a possibility of tyranny to follow. That is a realization that we generally, the mankind, had by around, I would say, 19th century. It doesn't mean that monarchy is no longer there. It was realized that even if we are retaining monarchy or kingship, there has to be a mechanism by which these three essential limbs, which constitute a governing apparatus, it is preferably kept separate. That is what we generally mean by the term separation of powers, in the sense that the legislative, executive, and the judicial wings ought to be different. This principle of separation of powers have to be borne in mind so as to have a meaningful discussion of the topic that we have taken for discussion today, for the reason that judiciary is one limb of this edifice. Other important limbs are the executive and the legislature. When we take out one limb and proceed to examine its role and function closely, that does not in any way mean that the other two limbs are insignificant. We are just confining our examination to that particular limb, as we may have to look into the other two limbs also. So the study or the scrutiny as to how the legislature, as we have envisaged it in India under the Indian Constitution, has worked so far, as well as the executive wing, also assumes relevance. But now we have chosen judiciary and have tried to identify the role that it has played in the course of the Constitution of India is relevant for the reason that we live in a juncture where we find that courts, not only in India, but across the globe, wherever we have a constitution, are starting to have greater importance. People tend to look upon courts as the last resort to which they can approach or go when they are faced with substantial issues in governance and in politics. So that is where we are trying to identify the role that the Indian judicial system has played when it comes to interpreting and understanding the document which we call as the Constitution. So, again, looking at this concept of separation of powers, what we have done in India is not something that is the same as it has been done in other countries. We have accepted this principle that separation of powers is necessary and is one effective means by which we can keep tyranny at bay. still we find there has to be some kind of a give and take, or there cannot be a strict compartmentalization of these three limbs. And there has to be some areas where there could be a kind of mutual give and take. So, just as Justice Cardoso, the great jurist, has said, when we speak of separation of powers and try and understand the role of judiciary and the part that it has to play, the approach that we should have should not be a kind of a doctrinaire or a pedantic or a rigorous approach. We have to look at the role of the judiciary vis-a-vis the role played by the other branches also. So, bearing that in mind, with that basic concept in mind, that judiciary forms just one part of one spoke of the wheel, and that the other parts are also equally important, we should now jump in to understand the evolution of the Indian Constitution. Because unless we understand how the Constitution of ours had evolved, how it was made, and what are the forces and the factors that played a prominent role in its creation or in its evolvement, we may not be able to fully understand and appreciate the role of the judiciary. What we did in India was a very unique and a unparalleled kind of process, not seen anywhere else in the world till then. There are certain legal system or societies which we call as the nightmares of a lawmaker. India was exactly in a similar situation. It's a nightmare as far as a constitutional law drafter is concerned, because this was a huge land with diverse people, nearly 400 principalities, independent states, all trying to come together to be put together, which faces poverty and also substantial inequality within itself, diversity in the form of religion, culture, geographical also, and which had been under the servitude for around 300 years under a powerful colonial power. We had within religious divisions, community divisions, communal divisions, caste, ideological divisions, lots of different kinds of ideologies playing in. So, the constitution that we evolved was a unique one wherein we tried to put together all these different kinds of concerns, ideas, and concepts that we had. We wanted to take all of these together. So we had to take out the best that was available in the world at that point of time. One of the biggest criticisms that is put against our constitution is that it is a collection of ideas from different parts of the world, and it is not uniquely Indian. That is one of those criticisms which is usually put against it. Personally, it is a wrong assumption. If we read through the constitution carefully, we find that even though the ideas would have been, or we might have been influenced by ideas from across the globe, and there is nothing wrong in doing that also, because we are learning from the experiences of other societies and other peoples who have tested with these concepts. And we needn't necessarily learn from our own mistakes. We can even be informed from the mistakes that they have committed. And we have adopted principles that suits our requirements. We have modulated it, we have refined it, we have fine-tuned it, we have rejected some of the essential principles of other constitutions, we have consulted with everyone, we have tested some of the principles as laid down in those constitutions, and before evolving it, We have tested as to how it had worked out there, and then we evolved our constitution. So the task before the Constituent Assembly was very peculiar. And that is where we have to understand how judiciary was positioned within our constitution. Since we are discussing the resilience and vitality of the constitution through the role played by the judiciary, we have to understand where is judiciary fixed within this constitution? What exactly is the role that it was supposed to play? Did it play that role? How is it playing as it stands now? And in the course of the last couple of years that we have seen it work, how has the working been so far? So it is in this premise that we have to understand, because the peculiar nature of the creation of the Indian Constitution. So if we look at it, the Indian Constitution gives the executive, the legislature, as well as the judiciary very peculiar, distinct, separate roles while maintaining a kind of relationship among them. So it is a kind of a quasi-federal constitution that we have. And this constitution, insofar as it is federal in nature, it had to take note of the interests of the federal units as well as that of the unitary state. So we have a federation which has substantial inclinations towards being a unitary state. So there was a need to have a supreme tribunal at the center, which would act as the interpreting body when it comes to questions pertaining to the Constitution. So that is something that we may have to specifically understand. Because unlike other countries, for example, other federal countries, like, for example, the United States, where they have their own Supreme Courts within each state and a federal court, the kind of method that we evolved so as to serve our purpose in India was to have one Supreme Court and a High Court in each of these states. And the idea was to make in checks and balances within this written constitution, so that the executive, the legislature, and the judiciary does not transgress into the spheres that have been set apart for the other. And at the same time, there is sufficient accommodation between each of these. So these three organs, I would say, are co-equal or coordinate. They are entitled to function within their own fields, and their area of jurisdiction and their powers are distributed by the Constitution itself. Now, the legislature makes the law, executive executes it the simplest way, as we can put it. The judiciary adjudicates or interprets it. Now, vis-a-vis the Constitution, the importance of judiciary assumes from the fact that it is the sole interpreter of the Constitution. Having said that, if we say it is the sole interpreter, then we are in one way restricting the rights of the legislature so as to vary it. That is, the varying the Constitution itself. So there is one school of thought which would say that you cannot term judiciary as the sole interpreter of the Constitution, insofar as you have retained to the legislature the power to amend the Constitution. So if the legislature has the power to amend, wouldn't it be the legislature that would be the final authority when it comes to the way in which the Constitution should be at a certain point of time? But that has been very clearly laid down, because this is something, just to give you an example of how we had drafted our Constitution. Once we had this draft ready, we had one great jurist by the name Venaga Narasimha Rao, who took the draft of the constitution and consulted with the best legal brains available at that point of time across the globe. And one such person with whom Narasimha Rao had discussion was Justice Frankfurter of United States. Because by that time, there was substantial experience in United States regarding the functioning of a constitution.
അവരെ
Because
പേരറിഞ്ഞൂടാ
they have experimented with this constitution and even have had a civil war. So
അതിന്റെ
it
പേര്
was
തന്നെ
always beneficial
ഡയറക്ടർ
because we had
പറഞ്ഞാൽ മതി.
substantially
അപ്പോൾ
adopted or we
മനസ്സിലാവും.
have been influenced by the principles as used in US. So Narasimha Rao took it there and asked Justice Frankfurter as to how things have been laid down and what would you suggest? So he said at that point of time by pointing to Article 21 of our Constitution and said that as it stood then, it had the word due process within it. No one shall be deprived of his life or personal liberty except following the due process of law. I'm just giving you this as an example so as to impress upon you the fact that the kind of deliberations and consideration that had gone into the making of our constitution. So it's not as if that this was a hodgepodge as it is now alleged to be. It was not. Frankfurter would say that this term which you have used there, that is a due process, we have tested it in US. And we have found that this clause could put in, it's not as if that it is something bad, but it is capable of interpreted in such a way that there could be substantial issues concerning governance that could flow out of it. Because the word due process as itself is nebulous. What do you mean by due process of law? Where does it start? Where does it end? What kind of process does it envisage? So he said that please take note of it. And that exactly is the reason why when we made our constitution, we did not use we rather supplanted the word due process with the word no one shall be deprived of his life or personal liberty except in accordance with the procedure established by law, not due process of law. And just giving this as an example because you will understand it later on when we proceed to discuss it. I will just leave it there and I will come back to it again later. Now, I was just pointing out the power of amendment. Now, I have to go back to it again for the reason that when we speak of the role of judiciary in ensuring the resilience and vitality of the Indian Constitution, we should also take note of the fact that it is the legislature which has been conferred. Once the Constituent Assembly had made the Constitution, it had to incorporate within it provisions regarding amendment of this Constitution. You should remember, we are speaking of amendment of the Grundnorm or the Grundnorm. Those vital, fundamental, basic principles which we find as the bedrock of our governance could be amended by the legislature. And the legislature consists of representatives who are selected over the course of time, based on the democratic process which we call as elections. Even though the Constitution does not use the word a political party anywhere in the Constitution as such, we know that elections are conducted and won on the basis of political affiliations. So, if you look at the Constituent Assembly debates, one of those important areas where the discussions centered was regarding the amendment provisions. Not as if that others were not discussed substantially. It's invariably that we should read the Constituent Assembly debates so as to understand how this document evolved. And there, during the discussion, it is Jawaharlal Nehru who says that if you ask me which is the most important provision in this Constitution, I would say that it is the provision regarding amendments. And the greatness of the man lies in the fact that he says We should not think that intelligence is our sole prerogative, or we are the only intelligent ones who can lay down a law that would govern this country for years or centuries together. The future generations would have their own way of looking at life and at governance. There should be a provision in the Constitution which should ensure that they have the facility to amend it so as to fine tune it so as to meet the requirements of their time. They have their own, they would be intelligent in their own way. They would be able to understand the situations they would be in. So we should incorporate amendment provisions in the Constitution, which would facilitate the fine tuning of the Constitution later on as felt necessary by the future generations. That is reflected in our amendment provisions. Now, the problem is, to what extent can you amend? Can you amend the Constitution in a way so that you take out the color of the Constitution as it stood when it was enacted, or when it was evolved or given unto ourselves? There is nothing preventing that. That's exactly why amendments are there. But are there some very basic tenets we consider as the bedrocks of our polity from which there cannot be any amendment, or rather any alteration? That is what we take, that will take us to the role of judiciary again in the form of basic structure doctrine. I will come to that. So all that I want to impress upon you at this point of time is the importance of amendment and the role that judiciary has, as well as that of the legislature, when it comes to the question of amending a constitution. Immediately after this amendment aspect, I should take you to the salient features. We all know what are the salient features of our constitution. Democracy is a salient feature. Multi-party democracy, the parliamentary system, the secularism, the insistence on freedoms, the individual freedoms, the right to life, the principle of secularism that lies embedded. These are all the salient features. I will leave the salient features there. Just I'm referring to it only to point out that judiciary will take note of these salient features when it comes to interpreting the Constitution every now and then, whenever it is called upon to do so. So, the role which was envisaged by the Indian Constitution to the Indian judiciary is not a role so as to provide for every contingency or every challenge that would evolve or come out in the life of a nation. So please don't look at judiciary as the panacea for all your problems. Constitution doesn't envisage that. It actually imposes this duty, or the duty is actually equally split between the three limbs. But the fact is that the constitutional law, even though it cannot provide for every possible contingency that could arise in the future, Constitution has to be, to a certain extent, vague and nebulous purposefully. That is what we now call as the great silences of the Constitution. So please don't expect the Constitution to provide you with the treatment for all the diseases that the nation or the state polity faces. There are some very poignant silences in the Constitution. The Constitution has not touched upon certain aspects. They have deliberately been silent on it. How should those silences be understood? And if there is an aspect that relates to that silence, how should that be interpreted and decided is a task which essentially falls on the judiciary. That I think it was the great judge Learned Hand, who said that there is a majestic vagueness in the Constitution sometimes, and it leaves room for doubt and disagreement purposefully. So please remember that if you find there is a room for disagreement or doubt within the Constitution, many a times it is deliberate, because that is necessary for the state to move on, to further its interests, to acclimatize itself with the different requirements of different generations. Many aspects may have to be left vague, and it is in those areas that the intervention of the judiciary assumes relevance. Now, let us come to the specifics. Up till now, I've been just touching upon the general aspects or the theoretical side. If we look into the specifics of the powers that are conferred on the Indian judiciary, that is on the Supreme Court as well as the High Court, I think that you have opted this topic as the role of judiciary with a very specific purpose. You did not say the role of the Indian Supreme Court. The topic for discussion today, and I congratulate the person who drafted it, because it's not the role of the Supreme Court. Had it been the role of the Supreme Court, I could have just given you a list of maybe 10 or 25 most important landmark cases and finished this discussion off. You just have to read through it and understand as to how the Supreme Court had played a role in interpreting and or in ensuring the resilience and vitality of the Constitution. Of course, invariably I have to touch upon it, but the sphere of discussion that has been set here today is larger insofar as the word used is judiciary. Well, when it comes to the question of who can interpret the Constitution, essentially our Constitution presupposes that judicial task of interpretation is to be exercised by the Supreme Court as well as the High Courts. So the Munsif Court or the trial courts, the district judiciary, does not essentially, that's the general sense in which we understand it, which I feel is wrong. If you just ask any law student, he would say that who interprets the Constitution or which court is concerned with the Constitution? It is the High Court and the Supreme Court. That I personally feel is a wrong way of looking at it. The Munsif's court, the magistrate court, the district court or the subordinate judges court, the entire hierarchy of courts have something to do with the Constitution. They work on the Constitution. And when a Munsif court or a magistrate court is deciding on such day-to-day matters like arrest of a person or application of a particular section, or maybe dealing with a petition, maybe even the family court, essentially does something that has some relevance to the Constitution or is working with constitutional legal principles. That we have to bear in mind. So it is not as if, and that's why I say that I congratulate the person who evolved this discussion topic, because resilience and vitality of the Indian Constitution and the way in which Indian Constitution has been interpreted is not the sole premise of the Supreme Court or the High Courts. The district judiciary plays a very prominent role, and personally I would say they are the main players in it, for the reason that they have direct connection with the citizens and they get to see as to how these avowed goals as laid down in the Constitution are working on the ground, which a High Court judge like me never get to see, not in the level in which a magistrate would get to see or a Supreme Court judge may be able to see. So the trial judiciary is the bedrock when it comes to the constitutional principles. Maybe the interpretational aspects may be done by the Supreme Court or the High Court, but it's not as if that the trial judiciary has no role to play, or the district judiciary has no role to play. There is a general saying that Indian Supreme Court is the most powerful Supreme Court in the world. Have you ever wondered as to why it is being said? I would also appreciate if this is a discussion, because rather than this being a monologue, if you are there, anybody there, you want to contribute, you are almost welcome to intervene and contribute also. Because rather than hearing me as a monologue, I think there should always be a discussion that would be more fair and would make more sense. Have anyone among you thought as to why it is said that the Indian Supreme Court is the most powerful Supreme Court in the world? This topic has something to do with our discussion. That is why I'm putting it forth. Well, I wouldn't say that it's totally wrong to say the Indian Supreme Court is the most powerful one because of one feature that it possesses. And that again has to do with the power of amendment that the parliament has. Indian Supreme Court is one of those courts which can even set aside an amendment that has been made to the Constitution. And as we will, when we discuss it further, we will see there have been a number of instances where the Supreme Court of India has actually done that. And so what we see in the way in which the high courts and the Supreme Courts have been fixed within the Constitution is that these courts have been empowered with the very prominent and important task of judicial review of administrative action, plus, to a certain extent, to intervene when there are legislative enactments which go against the stipulations or the tenets of the Constitution. So these two things makes the judiciary very powerful in India. When I say judiciary, please remember, I am not confining it to the higher courts alone. Judicial review of administrative action, as well as the power. Like, for example, we have the decision in Chandar Kumar case, wherein it was held that the powers under Article 226 to move a high court and under Article 32 to move the Supreme Court are integral and essential features of the Constitution, which reaffirms the fact that judicial action or the power to have a judicial review is something that is integral to our system, and there cannot be any kind of legislative intervention which may in any way confine or restrict this power. Now, with this background in mind, we have to see as to how the Supreme Court has dealt with this wide powers. Of course, the restrictions also that has been imposed upon it by the Constitution. I would say not only the Supreme Court, but also generally the courts in India. But it becomes easier for us to look at the way in which Supreme Court has done it for the reason that we follow this system of precedence or the legal reporting system as part of the principle of stare decisis, as they follow it in England, so that we have ready reference material to understand the impact of the decisions of the Supreme Court. And also we would be in a much better position so as to understand the way in which the law has evolved through various decisions of the Supreme Court. So we find that immediately upon the coming into force of the Constitution, judicial approach towards the Constitution has been one of strict adherence to the constitutional text. In jurisprudential language, we would call it as a positivist approach. There is something known as the legal concept of positivism. It's a jurisprudential school. They would say the literal interpretation of the law matters. Because even though we don't have much of a time here, our discussion on this topic will not be complete unless we look at the different ways in which jurisprudence impacts the functioning of courts, or the different schools of jurisprudence which look upon judicial functioning. The topic for discussion of ours is the kind of intervention that the judiciary has made so as to make the constitution resilient and vital. The topic that I just mentioned to you, that is the positivist doctrine, makes this task very simple and rather mechanical in a sense. Because the positivist school would say that law has to be implemented strictly in adherence to its text or the wordings. Even though I don't have time, I will just point out to you one more school of jurisprudence which says almost the opposite, so that you can understand the two extreme ends, and there are many in between. The extreme school on the other side would say that is a realist school, within which we have the American realists and the Scandinavian realists, who would say that the constitutional text, or rather the text of the statute, has no relevance. That is the extreme view that they would take. They would say a text or the constitution, as like this one that I have here, the constitution, the book that we have it here, which has all the articles in it, is not a law in the proper sense. They would say that this is a future law. Why? For the reason that, according to them, you can understand the hues and the colors of a statutory provision only when that statutory provision is applied to a set of facts. And the facts give flesh and blood to this skeleton of law that you find in this book. So you have to understand each of these statutory provisions, or maybe the constitutional provisions, from the fact situation in which it has been put into. Only then you have the total structure. And who does that? The courts does that. Once the court then looks into the legal provision from the point of view of facts and decides on that question, the ultimate decision that has been arrived at, then alone is it the law, according to the realist school. So the book as such is only future law. This aspect assumes relevance to our discussion because all that we are discussing about here is how the courts have breathed in life into the constitution. Because the topic essentially means is how has the judicial system breathed life into the book, the constitutional provisions, which would be otherwise dead letter words. I can give you a good example of this straight away, since I had mentioned to you the due process and the story of Frankfurter as well as Benaga Narasimha Rao. So Narasimha Rao came back and he scored off the term. I'm just giving it for the purpose of easy understanding. That's not the way in which it happened. Anyway, due process was stricken off, and in accordance with law was acted on, was incorporated. Now, how should you understand the words in accordance with law? Would it suffice if there is a law? A.K. Gopalan was arrested during the emergency. He challenged it under Article 21 by saying that my life and personal liberty cannot be taken away in this manner. State, this is exactly to deal with situations like this, that the due process part was taken away and in accordance with law was brought in. State comes in and explains it by saying that you were arrested for a valid reason and as per the provisions of this law that is there. Preventive detention law, which existed at that point of time. So So this is the law. Constitution only says life and personal liberty cannot be taken away unless otherwise than in accordance with the law. This is the law. Now then he proceeds to ask, this, can you call this a law? Because it does not satisfy the basic requirements of due process. Due process means tell a man as to why he is arrested. Give him an opportunity to defend himself. Try him after following a fair and transparent process. These are all due process requirements that are to be read in. Insofar as Constitution doesn't use the word due process, and it only says in accordance with law, here is the law. So you are being tested, or your life or your liberty is being taken away as per this law. Confronted with this question, later on we find that the Supreme Court says mere existence of a law is not sufficient. That law has to be fair and should comply with the due process requirements. So, the concept of due process, which was deliberately sought to be kept off from the Constitution, was brought into it through interpretation by the Supreme Court. That is a classic example of resilience and vitality that we are discussing. And just giving you one example, I can give you scores of examples of how through this process, not only the Supreme Court, but the courts in India, all through, right up to the magistrate or the munsif, have breathed life into these tenets of law, as would have been happily supported by the realist school. Now, who wins? The realist school wins. But that is where I started off by saying that immediately after the Constitution came into being, if we look at the way in which the judicial system approached the constitutional principles, and with the benefit of hindsight, I feel correctly so, was a strict positivist interpretation. They refused, the judges at that point of time refused to be swayed by ideology. Whatever was found as the ideological trappings laid down in the Constitution, they followed it. So that was the initial phase. It went on for a point. And later on, we find that there is an attempt by the judicial system to read. That is how actually A.K. Gopalan is an example of that. So as to read into it the principles that would further fundamental rights and the rights-based jurisprudence. So we have the cases like I don't think that it makes any sense to discuss each of these cases. I would just give you some of the cases, you can read through it. These are all cases that you would have already heard. Like for example, if we look through the way in which the Shankari Prasad's case, which was decided, wherein it was held that an act passed by the Parliament under its amending power under Article 368 would be valid even if it abridged any of the fundamental rights. You should remember that this is a decision by the court. There's a strict interpretation of it. And again, in Sajan Singh's case, it was supported. And by the time we come to Golaknath, a classic instance where 11-judge bench, the views expressed in Shankari Prasad and Sajan Singh case was reversed. And the Supreme Court held that fundamental rights are primordial rights for the development of human personality. Another instance where the court is breathing in life and shows the vitality or brings out the vitality of the constitutional principles. I'm not taking much time on Golaknath because Golaknath is a decision wherein actually, personally, I would say where it started off this this practice of interpreting the constitutional norms in a way so as to further the justice part. Now, if you ask me is there any decision which squarely points to the topic that we are discussing, and which is the case, which is the single one that one can choose out, which saved the republic, as some people say? It is the decision in Keshavananda Bharati case. So the takeaway from our discussion here, I personally would say, is to go back and read the decision in Keshavananda Bharati. And if you read through Keshavananda Bharati case, it's a 13 bench judgment, sorry, which examined the correctness of Golaknath's case and the aspect regarding the power of the parliament to amend the constitution. It was held in Keshavananda Bharati case that there is something called as the basic structure, and the parliament's power to amend the constitution would be subject to this concept of basic structure doctrine. And that case, some people say, single-handedly saved the republic. And it actually brought out the vitality of the constitution, and it saved the constitution in the sense that it laid a fetter against amending the constitution in such a way that the constitution becomes unrecognizable. If any legislature, if any parliament in the future tries to amend the constitution in such a way that it looks different from how it had been prior to the amendment, then there could be a violation of the basic structure doctrine if there has been a tinkering with some of those concepts which we call as so basic and fundamental to the structure of the constitution as we have evolved it. Now, subsequently, there is a phase which we call as the judicial activism phase of the judiciary. Even though generally it is something that is attributed to the Supreme Court, and we say that the Supreme Court passed through a phase of judicial activism. It is very interesting that we should look into this concept of judicial activism itself. Is it something desirable? Many a times we think that judicial activism is a kind of an approach that should always be there. Does it in any way interfere with, or does it tally well with the concept of separation of powers? What do you mean by this activism thing? Is it a situation where the court is going beyond its boundaries and entering into areas where it is not supposed to enter? If that is done for a justifiable reason, we applaud it. If it is a clear transgression of its sphere as set out by the Constitution, how far does it augur well for the constitutional document and the constitutional edifice that we have created is a question. So there are people who are great advocates of judicial activism. There are people who look at judicial activism skeptically because some term it as a double-edged sword. Some classic instances of judicial activism, as pointed out at that point of time, I don't have the time to go through the decisions and its intricacies. I would just suggest to you to read through the Maneka Gandhi case, the S.P. Gupta decision, the public interest litigations. That's an interesting aspect. Public interest litigations were epistolary jurisdiction, a kind of jurisdiction based on letters that are sent to the judges being taken up as petitions. These are all termed as the zenith of judicial activism as it existed, as it played out in India during that point of time. Some people say that that activistic phase is still continuing. There are another school of thought which would say that the period of activism has ended and the court is more conservative nowadays. But what all said and done, it should be seen that there has been instances over the last around 25 years, or at least 30 years,
Ah,
wherein there has been substantial inroads that are made into by the courts through their interpretative
ഈ
techniques.
പ്രോജക്റ്റിന്റെ ആണോ?
Well, prior to that, I can point out to you
ആ
from
ആ ആ ആ
different areas, like, for example, minority rights,
അതിന് ഡൽഹിയിലോട്ട്
the cases
കൊച്ചിയിലോട്ട്
like
അയച്ചു, പക്ഷെ അവിടെ പെൻഡിങ് എന്നാണ് പറയുന്നത്.
the Kerala Education Bill,
എന്നാണ് പറയുന്നത്.
the St. Stephen's College
അതെ.
decision. And on the same point again, Mohini Jain, Unnikrishnan, TMA Pai,
കൊച്ചിയിലോട്ട് ഫോർവേഡ് ചെയ്തിട്ടുണ്ട്. അപ്പൊ അവരാണ് അവിടുന്ന്
PA Inamdar case.
evaluator
All these are all cases which wherein the courts have emphasized the aspect of minority rights and could be pointed out as instances where the courts have breathed in life into the rather dead letter words of the constitution, or rather interpreted the constitutional principles in such a way so as to further the ideas that lie behind it. Then I can also point out cases wherein the criminalization of politics, wherein the politicians with criminal background, they participating in election. For example, there was this case of Association for Democratic Reforms, wherein the court held that proper disclosure of antecedents by the candidates. Because all that I'm trying to convey to you is, if you look through the constitutional document, you will never ever find any provision which would say that before a person can participate in an election under the Representation of People's Act, he should disclose its antecedents. Why do we call it as a act by the judiciary of bringing out the vitality of the Constitution? Because that particular clause or the relevant provisions of the Constitution are interpreted in such a way by the court so as to augur or further the basic tenets based on which the constitutional edifice has been put up. For example, democracy, a clean democratic process where the criminals would not make a way into our legislative apparatus. Another example would be the environmental jurisprudence, the whole gamut of MC Mehta cases, the Vellore Citizens Forum case, the Bittu Sehgal decisions, the entire gamut of environmental litigations are all arriving out or all culled out of the principles in the constitutional law, which there is no provision in the constitution, maybe except in the fundamental duties and also some in the directive principles, which would say that the environment has to be protected. Beyond that, the specifics of this are all the creations of the very resilient and vital interpretation of the constitutional provisions by the judiciary. I could also say the concept of gender equality in Vishakha case. After Keshavananda Bharati, if you ask me, I would point towards Vishakha case as the most important case evolved by the Indian judiciary when it comes to protecting the constitutional mandates. Because in Vishakha, you remember, that was the case where the sexual harassment at workplace of women was taken into consideration. The court laid down a very important principle which said that it is equally possible for the courts to look into universally recognized basic human rights and also into international conventions which are significant for the purpose of interpreting the principles of the Constitution, which includes Article 14, 15, 19, 1G, of course, Article 21 also. I think that's a classic example which conveys to you the vitality of constitutional interpretation, whereby the Supreme Court has brought out the hues and colors of our constitutional principles by interpreting it in such a way so as to further its objectives. Well, I don't want to go into DK Basu, where the rights of the arrested person was protected and upheld Well, cases where 32 and 226, which I mentioned, has already been pointed out as basic structure. So that was the second phase, I would say, after the initial cautious phase of the Indian judiciary in interpreting the constitution on a positivistic note. The second phase, which some people say is still continuing, wherein there is this judicial activism, the most creative of the phases, where the Indian judiciary interpreted the constitution in such a way that the rights of the citizens and the interests of the populace has been upheld and given priority, including minorities and all other groups. So then comes the phase, like for example, then I think Rajesh, I guess that am I exceeding time? Oh,
No, sir. Please continue.
I
It's
will.
very interesting.
I
So,
think I have exceeded. I'm so sorry. I just
no
lost
problem.
count
No
of time.
problem, sir. Please
I think I will conclude by pointing out one more decision which I think is very important, which actually shows the way in which the judiciary has intervened for the purpose of furthering the constitutional mandates, and that is the NJAC decision, where the appointment of judges, the collegium system. Actually, that itself would take at least 1 hour so as to discuss the way in which the collegium system was tested. The NJAC was set aside, and the collegium system still continues to hold sway. We are not on the manner in which the collegium system works or the appointments are made. We are on the point of how did the Supreme Court interpret the constitutional mandates so as to strike down a statute which was evolved by the parliament, which was approved cutting across political sphere, and said that we need to have a system or a method or a tribunal or an NJAC, as they call it, for appointment of judges, was stricken down on the anvil of the constitutional mandate of protecting the independence of the judiciary. And that takes us back to where we started from, the principle of separation of powers. NJAC is, or the striking down of the NJAC is upheld on the ground of upholding the principle of separation, doctrine of separation of powers, which now has been termed, and invariably so, correctly so, as a basic structure of the Indian Constitution. And so, even though we do have some situations where people now think, I did not mention the 42nd Amendment and the 44th Amendment because we didn't have time to that for discussing that and to see how the courts reacted to these amendments. That's a very interesting situation. So as to look, how did the courts react when the 42nd Amendment came in and when the 44th Amendment was came in? Certain parts of the 42nd Amendment was retained, while substantial parts were struck down. The classic instance where we will be able to discuss the same subject that we are discussing now. Now, I would say that to sum it up, that the Indian judiciary has all along upheld the principle that something again, I borrow it from the American jurisprudence. It says that government is a man's unending adventure. That's what we see when we look at mankind and the story of the civilization. It is a human adventure, and this adventure goes on. That is government or the system of governance. We have been toying with mankind has been toying with this different kinds of governance all through. No system is perfect. There is a need to give free play. Just as Nehru said, intelligence is not the sole premise of one particular generation. So, the actual unfolding of democracy and the democratic institutions may suffer from some inadequacies and imperfections. Always. What the courts are trying to do is to balance and to arrive at a arrangement or a system where there is a kind of furtherance or augmenting of those basic principles which we hold dear. And that, even though some kind of changes and permutations and combinations could be permitted as a justification of the felt necessities of the times that we live in, there cannot be a tinkering with the basic principles. Like, for example, some ask the question, what about secularism? Secularism is a word that was not there in our constitution when it was enacted. It was brought in by the 42nd Amendment. Well, when the 44th Amendment came, and now, even if somebody asks as to whether the word secularism is taken away from the preamble, does that make any effect? It may not make much of an effect because secularism is something that lies embedded across the principles of the Constitution. All through the secularism concept is there. Even if it is not clearly spelled out and termed as secularism itself, that is a basic bedrock on which our Constitution exists. Or can that be tinkered with at any point of time? From the way in which the courts have functioned and the basic structure doctrine, and of course, I couldn't go into the larger concepts of constitutional mores and things like that because of the paucity of time, constitutional morals. I think that many of these concepts, even though we may term it peculiarly, it is not the word as such that matters because the concept lies hidden through the provisions of the Constitution and the uh, tenor that our Constitution puts forth lies embedded very well within it. And the basic structure doctrine which has been evolved by the Constitution, again, I would repeat, is one pointer towards the manner in which the Indian judiciary has been very uh, innovative so as to ensuring the resilience and vitality of the Constitution. I thank you for giving me this opportunity. I wish you all the best.
Thank you, sir. It was a wonderful presentation. Absolutely no doubt about that. There are no two words to describe your presentation. I think you took me really back to those classroom days where every week, at least on 3 occasions, we had the fortune of listening to you. So thank you, sir. Thank you for this excellent presentation. It has been an absolute pleasure listening to you once again, sir. Now we request our director, RST, sir, to give his observations.
Thank you very much, sir, for your enlightening lecture, and we were greatly benefited by this. I'm not a student of law actually, but quite often what we hear in the newspapers and all, people say that there is indeed on many issues that the people call that the court should take suo cognizance of certain things, or kind of requesting courts for the kind of judicial activism, the word which you use. So, do you think that this there is a need for more judicial activism, and because there has been quite often we see people saying that court should intervene directly. So, what kind of view you have on this?
Well, I would explain it by a story. There was a postman in a village post office. He would come to the post office on time. He would do his work diligently. He would behave well with the customers. He would never send back a person saying that there is no change to return for the small stamp that one has to buy. And he was endearing and he was loved by everyone. By the time he was to be transferred, he had been the beloved of the entire villagers, and they decided to throw a farewell party for him. And everybody, speaker after speaker, came and started praising the man, that he is the best postman. He is the most wonderful postman that we ever had. And encomiums were showered on him. So then finally, an old man stands up and he comes and says, all that I need to tell you, my dear boy, that is towards the postman, is that you are a good man and you did your job well. And he said, I am not showering any encomiums on you because you did what you were supposed to do. You were supposed to come here at 10 o'clock. You were supposed to do everything that you were supposed to do as per your job. You didn't do anything special, but you become special for the reason that others before you did not do what they were supposed to do. So that is the reason why you are being congratulated. So please don't go from here to the next post office thinking that you are special or important. You are a good man, you did your job, and I congratulate you for it. So all these great praises that were showered on you, please don't take it to your mind. Similarly, judge is supposed to do something. The Indian Constitution envisages the judiciary to do certain things. It is doing what it is supposed to do. Those who are standing outside may look upon it as an activism. They may try to term it by different words. As long as the judges are not getting carried away by it and decides to be activistic for the purpose of being a judicially active judge or so as to further in judicial activism, what they are doing, personally, I would say, is what they are supposed to do as per the mandates cast upon them. They don't have a. The problem is, even though I do belong to that community, I always believe that judges do not have a constituency to address. They don't have an elected electorate who would question them. They are working in their own designated sphere. So, to cast larger aspirations on the judge or to confer them with powers or rather encomiums that they don't deserve may not be the proper thing to do. All that we can expect is that judiciary performs its task as it has been ordained with by the Constitution. That would be my answer.
Thank you, sir. Thank you so much. And now we are joined by our Director, School of Law. Madam, welcome to the program and
Thank you.
your observations, please.
Yeah. Actually, sir, I agree to your words that one should not take lots of appreciation to their heads. But I think I again need to congratulate Rajesh ji, the regional director, for organizing, scheduling this webinar, because it's a very valuable, I think, session, which has given insights into, I feel it's very precise and briefly you have talked about the evolution of the constitution, its framework, little bit about the form of government and then organs of the government, and then how the doctrine of separation of power is envisaged in our constitution, and that the precise manner which you described, I felt it very wonderful. And I think the role of judiciary is very crucial when it comes to the interpretation of the constitution, or we can say it's a purposive interpretation of the constitution. And I think I just wanted to point out here one thing, like constitution is a living document, we always say. But I feel it's a judiciary which is interpreting the constitution in a manner that it can adapt to the social or a political or a cultural changes which is happening. So I found your lectures are very wonderful, are very valuable, and I look forward that we can have more interactions with you in future. And the points which you have left in between, that it's, I know, because law is such a vast subject, so we should listen to some series of lectures from you. I hope so. Rajesh, you can organize that. Even the School of Law would also be grateful if you sometime visit to our school also. So thank you, sir. Thank
Anytime. Anytime.
Thank you, ma'am. And I'm sure, sir, with his natural inclination towards academic activities, will surely join us for future webinars as well. So, sir, before I request other participants to come in, I had a basic doubt. Judiciary nowadays is confronted with a lot of issues related to center-state relations. And many of these issues are very contentious even, right from the Supreme Court on to the High Court, even we have aspects related to center state issues. So in this regard, where is the Indian judiciary actually placed? Because whatever interpretation you put into place, it is bound to injure one party or the other, or may not make one party happy vis-a-vis the other party. So from the judicial perspective, how do you look at these cases?
Well, Rajesh, actually, federalism is a basic structure. And Indian federalism is one of a peculiar kind. Supreme Court has always emphasized this unique nature of Indian federalism. And I personally believe that it is something that is so natural in the course of a federal entity that these pushes and pulls keep on happening, not only between the center and state, as well as between the states also. If we look at the states inter se, there are disputes which are at times given or they take up a big role, or rather they may flare up in certain senses. But the uniqueness of our constitution and the way in which the Supreme Court and the other courts have handled it so far has been that it's been a kind of very cautious, strict adherence to the tenets as laid down in the constitution, so as to retain that federal structure and also to achieve that balance between the center and state. So, as you pointed out, there may be disgruntlement, there may be uh, disappointments, but the point is, fortunately for us all along, and we should appreciate the role played by the political parties and also the executive of all the states for that matter, that we don't see the kind of uh, vehemence when it comes to interstate or between the center and the state issues. And once the Supreme Court decides on it, there has been a substantial acceptance of the decision. And that I personally see is the most bright aspect of the Indian polity and the success of our document, the Constitution, which envisages this federal setup.
Thank you. Thank you so much. Our Assistant Regional Director from Vadagara, Dr. Pramila O, wishes to raise a point. Ma'am, please come on.
Good afternoon, all.
Yes, madam.
Yeah, respected Shyam Kumar sir, RC Director sir, Dr. Rajesh sir. First of all, I appreciate the effort taken by the RC Director and the Dr. M. Rajesh for conducting such a wonderful session, sir. Again, I appreciate Advocate Shyam Kumar sir, very attractive and informative session. And I have a point, a doubt, a clarification about what role has the judiciary played in safeguarding the federal structure of India, sir. And how does it mediate conflicts between the central government and states without overstepping its constitutional mandate?
Hello.
Yes,
Rajesh?
but I think to a certain extent this overlaps with the question
Yeah.
raised by Rajesh, I guess.
Okay, okay. That's
So there are mandates, and up till now, if we look at, we can take any of these instances. For example, the one of those main areas have been the question of sharing of river waters, and that has been something that been a bone of contention between the states. Maybe it's between Kerala and Karnataka and Tamil Nadu, or between Tamil Nadu and Kerala, and also between other states in the north. So all these issues, we have seen that the constitutional mandates have been upheld, and these states have always been
region center
willing
okay.
and have very happily accepted to the
Region
decisions that
center
have been rendered by the Supreme Court from time to time. And
Everyone
as I
submit
was pointing out, this willingness shows the maturity of our political system in ensuring that the mandates of federalism as enshrined in our constitution is upheld and adhered to by all the units, including the state as well as the federal governments.
Thank you, sir.
Thank you, sir. Thank you, ma'am, for the question.
Thank you, Rajesh, sir.
Anyone else who would like to ask a question or give a comment is welcome.
Okay.
Jalajumari, please.
Sir, namaskar, sir. Respected Shyam Kumar, sir. Respected Regional Services Division Director, sir. Rajesh, sir, my friends. Actually, a lot of thoughts came into because sir was telling about the approaches of different schools. I have a doubt
Yes.
because philosophically we are telling the truth is absolute. But in judiciary, truth is always relative, no doubt. Because our experience is like that. Whether the contradiction between the positivistic school and the realistic school makes the truth relative. That is one thing. And one additional thing, sir. Because of this, because truth becomes relative, because the legal brains and the brilliant interpretations make so. So the laymen, I think the common people, they are always afraid to approach many matters because of sometimes it may be because of the financial crisis, and they are going away or they are kept away from the judiciary. Is there any justification or truth? I'm not relative truth. I'm asking you again one absolute truth. I don't know whether it is correct or absolute truth is something else. If as a layman, my opinion is like that from my experience also. Sir, what is sir's comment on it?
Generally, when we look at the legal systems, the motto that I have seen when I started my practice that adorned the walls of the High Court as it stood then in the old building was Fiat Justitia Ruet Caelum. That is, justice will be done even if the heavens fall down. That is a principle that we have adopted from the Western legal thought. It says that whatever happens, justice will be done. Now, our Indian judicial system has adopted the motto as Satyameva Jayate, which means the truth always wins. Since you mentioned about truth and the relevance of truth in the justice delivery mechanism, I feel this motto that Indian judicial system has adapted for itself and which you will find enshrined under the Ashoka Stamba emblem, Satyameva Jayade, which is an integral part, continues to hold the sway. Now, having said that, there could be some relativity with respect to truth. If we go or look at it philosophically, what is truth? or what is justice. There could be an element of relativity in terms of justice also. But what we should generally understand is that when we use the term justice as we use it when it comes to court decisions, it is not justice in the abstract sense. Justice, according to one, may be injustice from the perception of another. So, what the courts do is justice in accordance with the law. It makes substantial uh, relevance in the sense that justice as rendered by the courts are justice in accordance with the law. So, that is what leads us to truth, is the concept that we follow. So, we have three concepts which admittedly have rather unclear contours. One is justice, the other is truth, and the third one is law. Well, as regards law, we have some clarity because the Constitution tells us what law is, or the Indian Constitution has explained as to what is law as has been used in the Constitution. So, personally, what I feel is, I will again point this out by an example. There is no dearth of confidence in the general populace in the judiciary at all. I believe that the common man has utmost faith for the judiciary. I will say this with an example because I have seen in the High Court people, generally because in the High Court the clients need not come. It is the lawyers who argue, unlike in the trial courts where the people or the citizens may have to come for different purposes, maybe as a witness or for rendering evidence and all. But rarely, when people come to the High Court, I have seen them removing their slippers outside the courtroom and entering the courtroom as if that they are entering a very sacred premise, like a temple or a place of worship. That is the feeling that they have. That's a very genuine feeling. That actually, I would say, points to us the kind of faith that the people have in the system of judicial administration. So that is what guides us so as to ensure that this faith that the people are showing by this act of removing their slippers outside and entering the courtroom, that is what we are trying to uphold and cater as judges in the courts. So there is no dearth at all for faith that people may have in the judicial system. And there may be people who might have experienced the legal system and uh, might have experienced some disappointments in the way that they might have lost their cases. Such type of disappointment is always bound to be there when a person uh, moves the court and gets a result which he or she was not accepting. That may be a personal disappointment for the person, but that is no reason so as to cast a general observation on the system at large, because the system at large moves on this principle of Satyameva Jayate.
Thank you, sir. Madam, anything you want to add?
I wanted to add so many things, but I don't want to make this platform as an argumental. But, being a judge, sir can say like that only. But that is what? That is the truth. Actually, that is the truth. I know that. But even though I was asking that the contradictory and whether the resilience and vitality will be lost in between the contradictory approaches of this positivistic school and the realistic school. That is what I was thinking like that. Sir clarified it very from the point of a judge. That also I appreciate. Thank you, sir. Thank you very much.
Thank you, sir. Thank you so much. Anyone else who wishes to put a comment or a question, kindly unmute and do so. I think the session has been very exhaustive, and most of the aspects have already been covered. So, as always, it was a wonderful session with Shyam Kumar sir, the Honorable Judge from Kerala High Court. To conclude the proceedings of this particular program, I would now request our Assistant Regional Director, Dr. Priya Pradeep, to propose a formal vote of thanks.
Very good afternoon, all. Now we are moving to the concluding part of this session. At the outset, I would like to, on behalf of RC Trivandrum, I would like to thank our chief guest, Justice Shyam Kumar sir, for sparing his valuable time with us. The session was very informative, and you have presented the session in a very interesting way also. Thank you very much, sir. I also like to thank our RST Director, Dr. UC Pandey, for joining with us today and delivering the welcome address. Thank you, sir. And thank you, Dr. Director, School of Law, also has joined with us. Thank you for her comments and views regarding this topic. Thank you, ma'am. I also like to thank our academics and staff members from various regional centers and study centers for joining this program and their active participation in this session. Thanks to all. And finally, I would like to thank our Senior Regional Director, Dr. M. Rajesh, for his support and guidance in conducting this program. And a big thanks to our RC team for their support and cooperation in conducting this program. And thank you very much.
Thank you, ma'am. This draws to a close. A wonderful session, sir. I am extremely thankful to you, not only because you have joined, but also taken time out of your very busy schedule. I know that today you have another program. You somehow managed time out of that program to join us virtually, which is wonderful and great, sir. In future also, we will be contacting you, and as per your convenience, you will schedule other sessions for the benefit of staff and students. Thank you, sir.
Thank you.